Welcome to the National Bankruptcy Academy video series. I'm your host, Robert Schaller, an attorney with over 34 years of experience and a registered certified public accountant. Today, we'll be discussing the voluntary petition and related documents with a line-by-line analysis and real-world commentary. I hope you enjoyed the video. Every individual seeking Chapter 7 bankruptcy relief commences a case by filing a petition. But what constitutes a petition? Unlike the U.S. district courts that give great latitude to drafters of a civil complaint, the U.S. bankruptcy courts do not give similar latitude to drafters of a Chapter 7 petition. Instead, the bankruptcy rules require an individual seeking bankruptcy relief to use a specific national form prescribed by the Judicial Conference of the United States. These rules are strictly enforced. The petition form may not be changed as to affect wording or the order of presenting information. This course focuses on the petition titled Official Form 101, Voluntary Petition for Individuals Filing for Bankruptcy. This form applies only in cases filed by individuals. This form must be contrasted with other types of petitions used by non-individual debtors, such as corporations. However, for simplicity, the current Official Form 101, Voluntary Petition for Individuals Filing for Bankruptcy, shall simply be referred to as the petition. A bankruptcy petition can be filed by a person alone or by a person and his or her spouse together. A bankruptcy case filed by a person alone is called an individual case. A bankruptcy case filed by a person and his or her spouse together is called a joint case. An individual filing for bankruptcy relief is called a debtor. Now, let's turn our attention to this bankruptcy form with a line-by-line analysis with real-world commentary. I hope you enjoy the video. Before we begin examining the bankruptcy document, consider reading the suggested book, Do-It-Yourself Guide to Filing Chapter 7 Bankruptcy. This desk reference book provides step-by-step instructions for filing a Chapter 7 petition, Schedules A through J, the Statement of Financial Affairs, the Statement of Intent, the Chapter 7 Statement of your current monthly income, and the Chapter 7 Means Test Calculation. The book is available at www.diy-bankruptcy.info/shop or go to www.diy-bankruptcy.info and click the bookstore link on the main menu. Today we're going to be talking about the voluntary petition for individuals filing for bankruptcy, Official Form 101. It's important to note that there are many types of petitions. Today we're only going to focus on the voluntary petition for individuals. At the top of the form, there's a box that says, fill in this information to identify your case. This box allows the court to know in what court are you going to be filing the bankruptcy case. And there's a pull-down menu, so let's explore that. Here it says United States Bankruptcy Court for the, and with a pull-down menu, you'll identify which district in which you're going to file the bankruptcy case. We're using an example today of George and Martha Washington, and they live in the Eastern District of Virginia. So I'll pull down the menu, and we're going to search for the Eastern District of Virginia. And there it is. So I'll click on that. The next they ask is, what is the case number, if known? Now, in the beginning of a case, before it is filed, there is no case number. It is just simply information on your computer. Once the case is actually filed with the clerk of the U.S. Bankruptcy Court, the clerk will assign a case number, and all future pleadings must have that case number on it. But for this example of George and Martha Washington, there is no case number because the case has not yet been filed. So we'll leave that blank. Next to the right, it says, what chapter are you filing under? Of course, the attorney must know what is the chapter that they're seeking relief for. Chapter 7, Chapter 11, Chapter 12, or Chapter 13. The focus of this video is Chapter 7, a consumer bankruptcy. So we're going to check the Chapter 7 box. To the far right over here is another box, and it's labeled, check if this is an amended filing. This is not amended filing. This is the first time the case is going to be filed, so this box would not be checked in the example of George and Martha Washington. However, if it was amended filing, then you would go ahead and check the box as I'm doing now, and then you'd move back over to the case number if known, and you would enter the case number in. For example, 20B12345. But since this is a fictitious case of George and Martha Washington, the case has not yet been filed. This would be left blank. So I'm going to delete the case number. And I'm also going to uncheck the box to the right because it is not an amended filing. Next, we have to review down below the instructions for Official Form 101, the voluntary petition. The instructions say the bankruptcy form uses you and debtor 1 to refer to a debtor filing a loan. A married couple may file a bankruptcy case together called the joint case. And in joint cases, these forms use you to ask for information from both debtors. For example, if a form asks, do you own a car? The answer would be yes if either debtor owns a car. When information is needed about the spouses separately, the form uses debtor 1 and debtor 2 to distinguish between them. In joint cases, one of the spouses must report information as debtor 1 and the other as debtor 2. The same person must be debtor 1 in all of the forms. Now let's move down the form to Part 1. Part 1 is titled Identify Yourself. And if you'll notice, there's two columns. One says About Debtor 1, and the second column says About Debtor 2. Throughout these forms, we're going to distinguish between debtor 1 and debtor 2 depending on the portion of the form. So here on line 1, it's called Your Full Name. Write the name that is on your government-issued picture identification, for example, a driver's license or passport. And make sure you use the exact name that's on the driver's license. Because later on, when the debtors at the Section 341 meeting of creditors, they're going to be comparing the name on the petition with the name on the government ID, so make it exact. So for example, in this case, we have George and Martha Washington. So the first name would be George. He has no middle name, and the last name is Washington. Over here on debtor 2, they want the second spouse. That would be Martha Washington. She has no middle name either. And neither one of them have a suffix, like a junior, a senior, a second, or a third. If they did, then that would be appropriately labeled in the box below the last name. Now line 2 says, list all other names that the debtor has used in the last 8 years, including any married or maiden names. So for example, if George Washington had a nickname like Gabby, or just an abbreviation like GEO, you'd include that name. And the reason you do that is they want to make sure that creditors are listed and creditors can identify who in fact is actually filing the bankruptcy. So for example, if George Washington completed a loan application using the name Gabby Washington, then it would be difficult for the creditor to realize that this George Washington who's filing the bankruptcy is the same as the Gabby Washington that was a lessee under, say, a car lease. So let's use Gabby Washington under line 2. Now over here on debtor 2, which is the wife Martha, let's assume in this particular case George and Martha were married 5 years ago. Then she would have been using her maiden name within the last 8 years. That is, the 3 years prior to the 5 years that they've been married. So in her name, let's say her name was Martha Dandridge. That's her maiden name. Now let's move down to question 3. Question 3 asks the debtor to list the last 4 digits of the Social Security number or Federal Individual Taxpayer Identification. Notice that the first 5 digits are X'd out, XX-XX, and then leaving room for the 4 remaining digits. So let's say that George Washington's last 4 digits are 1, 2, 3, 4. And let's further say that Martha's last 4 digits are 4, 3, 2, 1. Now notice that question 3 says to list the Social Security or Individual Taxpayer Identification number. So what is an ITIN number? Well, the Individual Taxpayer Identification number is a 9-digit number issued by the U.S. Internal Revenue Service to individuals who are required for U.S. federal tax purposes to have a U.S. taxpayer identification number. but who do not have and are not eligible to get a Social Security number. So, for example, let's assume you're an alien resident who's allowed to work in the United States, but is not issued a Social Security card. They may be issued an ITIN number by the Social Security Administration. So when they fill out a tax return, they would use the ITIN where other people might use a Social Security number. And on this particular form in the bankruptcy court, the voluntary petition, they would use the ITIN number instead of the Social Security number. In a very rare case, you would have both, but if you were to have both, then that might be a red flag to an attorney that one of the numbers might be illegal. For example, someone who is illegally using someone else's Social Security number. So that'd be a red flag. But in a normal case, you would have either one or the other, and you list it here on line 3. So let's move down to line 4. At the very top of page 2, there's a bar that says debtor 1. And I wish the form said debtor 1 and debtor 2, because you're supposed to put both debtors' names down if this is a joint case. So in this case, we put down George and Martha Washington. And I'm sure the header is there so that it appears on all future pages. So if the staple ever came out on a physical document, or if it ever got separated on an electronic document, then they would know what name applies to the various pages. To the far right, there's a case number if known. That means if this is an amended petition, as we talked about earlier. Since this is the first petition and the case has not yet been filed, the case number is left blank. So let's move on to line 4. Line 4 asks the debtor to identify any business names and employer identification numbers that have been used in the last 8 years. And the employer identification number is sometimes called the EIN. So what is that? Well, an employer identification number is a 9-digit number assigned by the IRS. So it's sort of like the ITIN. But the EIN number is used to identify the tax accounts of employers and certain others who have no employees. The IRS uses the number to identify taxpayers who are required to file various business tax returns. EINs are used by employers, sole proprietors, corporations, and partnerships. So in this particular case, George Washington has a EIN number because he is a sole proprietor of a business. Okay, so we would fill in the business name on the first box, and that is Cherry Tree Services. The second line below is also a business name in case the debtor has more than one business. And the EIN number is identified for the business, which I've just added. Now over here on debtor 2, that's Martha Washington, they ask the same thing. Does she own any business that has a business name or employer identification number? But in our example, she does not. So we're going to check the box here saying, I have not used any business names or EINs. So let's move down to question 5. Question 5 asks, where does the debtor live? Which is really a residence question. What is the debtor's residence? So you'd put down the street residence of where they live. So in this case, we're putting down 3200 Mount Vernon. And that's in the city of Mount Vernon in the state of Virginia with a zip code of 22121. And it also asks for the county. Now that's important because within each state, there's a federal bankruptcy court. Some states have more than one federal bankruptcy court. And typically, they decide which court is the appropriate court depending on the county that the debtor lives in. So within, for example, Chicago, the federal bankruptcy court sitting in Chicago covers many counties. And that would be Lake County and Will County and Cook County, for example, and DuPage, and some other counties. And they would look to see where does the debtor live. And if they live in that county, they're assigned to the bankruptcy court of that district. So make sure the county is accurate. Over to the right, it says if debtor 2 lives at a different address, add that. In this particular example, Martha Washington lives with George Washington, so it is not a different address. Again, they're only looking for a different address, so I would leave this blank. Now notice the boxes below on line 5, the bottom boxes. The instructions say if your mailing address is different from the one above, fill it in here. So if the mailing address is the same as your residence, then you just leave this blank. But sometimes it's a different address. So for example, somebody might want to have important mail sent to a post office box, in which case they would then put that information here. So they're not claiming they live or reside at the post office, it's just where they want to get their mail. So let's assume in this example that he wants to send it to the P.O. Box 1234, and let's say that's also in Mount Vernon. Okay, so by putting in the P.O. Box 1234, what that shows to the court is the debtor wants information sent to the P.O. Box, even though he lives at 3200 Mount Vernon, and that's his physical residence. Now over here, we're leaving that blank because that means Martha Washington also wants all the information sent to the P.O. Box 1234. Let's move on to question 6. Why is the debtor choosing this district to file the bankruptcy? So if you remember at the very top of the first page of the petition, it requires the debtor to indicate in what district is the debtor going to be filing the bankruptcy. This question, number 6, explains why the debtor is choosing the district in which the petition has been filed. And there's really 2 choices on this form. The first one, which is the most common one, is you check the first one that says, over the last 180 days before filing this petition, the debtor has lived in the district longer than any other district. So it's a simple math equation. You look at the last 180 days, and where has the debtor lived more than any other place? So I'll give you an example. Suppose the debtor moved from Illinois to the Eastern District of Virginia, and he moved there 92 days ago. Then the analysis would be, well, where has he lived longer within the last 180 days? And the answer would be, well, within the 180 days, 92 of those days would have been in the Eastern District of Virginia. And the other, if my math is correct, 88 days would have been in the Northern District of Illinois, where Chicago is. So that means that he's appropriately filing in the Eastern District of Virginia because he's lived there the majority of the last 180 days. Now let's assume that he doesn't want to file there, and let's further assume that George Washington has property, substantial property, over in Chicago. So instead of checking the first box, he would check the second box, say, I have another reason. And again, this is assuming he wants to file in the Northern District of Illinois. So it says, explain. Well, why? And notice in parentheses it says, see 28 U.S.C. section 1408. Well, that's the venue provision for bankruptcy cases. So 28 U.S.C. section 1408 states as follows. Except as provided in section 1410 of this title, a case under Title 11, which is bankruptcy, may be commenced in the district court for the district in which the domicile, residence, principal place of business in the United States, or principal assets in the United States is located. So let's again use this example of George Washington has his principal asset in Chicago. If that's the case, then he could fill out the second portion. So let's do that. So I've added debtor has the principal asset located in the Northern District of Illinois. So certainly at the section 341 meeting of creditors, the trustee will inquire what is that asset. But that asset would have already been identified on Schedule A/B, which we'll get to in a later course. So by putting this down and checking this box, and of course assuming it's true, that means George Washington would have 2 options, 2 separate places where a bankruptcy could be filed. If he's lived at Mount Vernon in the last 92 days, he could check the first box and file in the Eastern District of Virginia. On the other hand, since his principal assets located in the Northern District of Illinois, he also has the opportunity to file this case in the Northern District of Illinois Bankruptcy Court. And there'd be a strategic advantage one way or the other, which is beyond the scope of this video. So let's assume he wants to file in the Eastern District of Virginia. So I'm going to delete this information about the Northern District of Illinois. I'm further going to uncheck this box and instead check the first box, saying he's lived there over the last 180 days. And over here on debtor 2, I'm going to check the first box as well, because George and Martha have lived together in the Eastern District of Virginia over the last 92 days before the case is filed. Now let's move down the form to part 2. Notice at the top of the form it has the header George and Martha, Washington. So part 2 is titled, Tell the Court About Your Bankruptcy Case. Line 7 requires the debtor to indicate the chapter of the bankruptcy code in which the debtor is choosing to file under. Now you might remember on the first page, at the very top, the debtor is required to identify the case and the chapter in which the case is being filed under. We checked Chapter 7 for George and Martha, Washington. So again, we're going to check here again on line 7, Chapter 7. The next is line 8. How will you pay the fee? And there's 3 choices for how the debtor is going to pay the fee. The fee they're referring to is the government filing fee that's required for filing a bankruptcy case. That fee changes from time to time. So before the case is filed, you want to contact the clerk of the bankruptcy court for the district in which you're about to file the case. Thankfully, they all have websites, and you can also get the information from their website. The first one, that, as I'll check here, says, I will pay the entire fee, that's the filing fee, when I file my petition. That is checked if the debtor is going to be paying the entire fee when the case is filed. If the debtor is filing on its own, then the debtor would pay with cash or cashier's check or a money order, but not a personal check. On the other hand, if the case is being filed by an attorney, the court would certainly take cash, cashier's check, or money order, but they'll also take an attorney check as long as the check has a pre-printed address on it. But more commonly, especially for skilled bankruptcy attorneys, they're going to be filing the case electronically. And in fact, many of the districts require the cases to be filed electronically if you're an attorney. So you'd use a credit card. The second option, let's uncheck the first and check the second, says I need to pay the fee in installments. An attorney representing a debtor typically would not check this box because typically the attorney would be paid in advance. And an installment agreement would not be required because the filing fee would have been paid in advance with the attorney's fees. But for those cases where it's either filed by an individual, not an attorney, or maybe a pro bono case where the attorney is not being paid, this box would be checked. And again, it says I need to pay the fee in installments. Now, installments can be one payment, could be 2 payments, or 3 or 4 payments. I've actually never seen more than 4 payments, but 1, 2, 3, 4 are available. And obviously, a 1 payment would just be paying it in full. And there's a special form. Notice to the right, it says Official Form 103. And that's the application for individuals to pay the filing fee in installments. The courts are generally pretty liberal about doing that in terms of allowing you to make it. And you would choose the dates you want to choose, but you have to stick to those dates. If those dates are not honored, typically there will be a motion to dismiss, either sua sponte by the court or by the U.S. trustee. So let's uncheck that and go to the third option. The third option is I request that my fee be waived. And the waiver of a fee I don't think would ever happen if the attorney is being paid in a case, because the court would want to make sure the court is paid before the attorney is paid. But in the case where you're doing it pro bono or a pro se case where the debtor is filing by themselves, that box may be checked. And again, let's read it. It says, I request that my fee be waived. By law, a judge may, but is not required to, waive the fee and may do so only if the debtor's income is less than 150% of the official poverty line that applies to the family size the debtor is filing under. Now, in my experience, the court is very hesitant to waive that fee. They'll do it, but they're very hesitant. And the reason they're hesitant to waive that fee is more of a protection for the Chapter 7 trustee. The Chapter 7 panel trustee gets paid a very small fee for each of the no asset cases. Those are cases where there is nothing for the debtor that's going to be liquidated, and there is no money to pay any of the creditors. In which case, the Chapter 7 trustee will only get a small fee, and that fee comes out of the filing fee paid at the time the case is filed. So the judges really want to protect the trustee, otherwise the trustee's working for free. Now, I've seen the judges waive that fee, but the debtor really has to be unable to pay the money. And then when they are unable to pay the filing fee, then I have seen the judges waive it. Okay, so let's move on to question number 9. Question 9 asks the simple question, has the debtor filed for bankruptcy within the last 8 years? So certainly an attorney would ask the debtor if in fact that has happened. But the debtor's attorney should also not rely upon the debtor. The debtor's attorney should look under the PACER system, P-A-C-E-R. The PACER system is a computer system that allows attorneys to check up by Social Security number on whether the client has filed a bankruptcy case in the past. And certainly if the debtor has filed a bankruptcy case in the past, and the debtor is representing themselves, the debtor would know whether they filed bankruptcy before or not. And you're looking for the date the case was filed, the petition date for the last year. So in this particular case of George and Martha Washington, they did have a prior case, and let's assume it was a case filed in the Northern District of Illinois before they moved to Mount Vernon. If you remember, we used earlier the example in line number 6, when we're talking about venue, that they had their principal asset in the Northern District of Illinois. So let's just assume that that's the case. So under question number 9, it says, have you filed bankruptcy in the last 8 years? They would check yes. And in what district would that be? That would have been the Northern District of Illinois. And when was the case? Let's just make that up and say it was May 15th, 2018. And the case number you'd have to know because the case has been filed, so it exists, and you would have looked it up at a minimum from the PACER system online. So let's just say it was 18B 98765. And this question is asked for a variety of reasons, but the biggest reason is eligibility. The bankruptcy court needs to know, are you eligible to file Chapter 7? So, for example, by filling out line 9 and saying, yes, I filed in the Northern District of Illinois in 2018, that means that the court, through the trustee, would look up to see, well, what kind of case was that? And is the debtor eligible for the current case? So let me give you an example. Suppose that George and Martha Washington had filed a Chapter 7 case on May 15th of 2018. Line 9 would require the debtor to identify that. Well, since George and Martha Washington are trying to file another Chapter 7 bankruptcy case here, that would cause a problem. And this line 9 would alert the court that the debtor are not eligible to file because you're not allowed to file a second Chapter 7 bankruptcy case when only 2 years have expired since your first Chapter 7 case. Now let's assume something different. So let's assume that George and Martha filed a Chapter 13 case in the Northern District of Illinois when they were trying to save, let's just say, a home in the Northern District of Illinois. That was their primary residence, and it was also their primary asset. They filed a Chapter 13, but unfortunately, the case got dismissed because George and Martha are no longer employed, and they couldn't afford the Chapter 13 repayment plan. So the case got dismissed. George and Martha Washington moved to the Eastern District of Virginia to live in Mount Vernon. So line 9 would indicate that there was a prior bankruptcy case, but notice it doesn't say what chapter. Now, I think that's the limitation on the form. If I was designing the forms, I would have indicated what chapter, but that information is just not eligible on this form. So you leave it up to the Chapter 7 panel trustee to look to see what was the prior chapter. Now, in this case, we're saying that they did actually file, so I'm going to leave that on line number 9. Line 10 says, are any bankruptcy cases pending or being filed by a spouse who's not filing this case with you or a business partner or an affiliate? So in this particular case, the spouse is Martha Washington. So that wouldn't be a separate case being filed by Martha because it's a joint case and they're filing together. And let's also assume that the debtor, George and Martha Washington, don't have any business partners who are affiliated that have filed bankruptcy. So they would check the box, no. Let's move on to line 11. Line 11 asks the debtor, do they rent their residence? So they're not asking for rental of any commercial property or any apartment building they may own. They're talking about their actual residence. Do they rent it? So if the answer is no, they own the property, as George and Martha Washington do, then we would check the box no. But let's assume they do rent their residence, okay? In which case we would uncheck the box no. And let me give you an example. George and Martha Washington lived in Chicago and they owned a house there. That was their principal residence. However, they were unable to sell the house after they lost their jobs. So they moved to the Eastern District of Virginia and they rent there. Okay? And they're filing Chapter 7 to get rid of the mortgage debt related to the house that was owned in Chicago, the Northern District of Illinois. In which case, they would then check yes, that they in fact do rent their residence. Well, that then leads to the next question. Has the landlord obtained an eviction judgment against the debtors? So if Martha and George moved to the Eastern District of Virginia and they rent a home there, but they have not had an eviction judgment against them, they would check the box saying no and move on to line 12. But let's assume that they in fact have. They've moved to Mount Vernon and they're renting a home there, but because they continue to be unemployed, they fell behind on the rental payments, and the landlord has filed an eviction action against the debtor. Well, that's not enough yet to check the second box. The second box is checked is if the landlord has filed an eviction action and obtained an eviction judgment against the debtor. If that is the case, then they would check the second box. And you notice over here, they identify Form 101A, which is the initial statement about an eviction judgment against you. And now that's important for the automatic stay purposes, because assuming there's no eviction action at all, the filing of the bankruptcy case would act as an automatic stay or an injunction against the landlord, and the landlord couldn't take any action against the debtor because of Section 362 of the Bankruptcy Code, without going to the bankruptcy court first for getting permission to go ahead and sue for an eviction. On the second hand, let's assume that the case has started, but yet the no eviction judgment has been entered. The debtor again would have automatic stay protections under Section 362 against the landlord, and the landlord would have to go to the bankruptcy court to seek permission to go ahead with the eviction. And then finally, the third scenario is the landlord has already received an eviction judgment against the debtors prior to the bankruptcy case being filed. So let's assume the eviction is going to happen the day before the bankruptcy case is filed. In that event, the debtor rushes to the bankruptcy court and files the bankruptcy case, hoping the automatic stay provision would block the eviction. But sad for the debtor, that would not be the result that he's looking for. Instead, because the eviction judgment was already entered, the bankruptcy court would not block the eviction, and the landlord would be allowed to go ahead with the eviction. And that's why line 11 is super important. Let's move down to part 3, line 12. Part 3 is titled Report about any business the debtor owns as a sole proprietor. Question 12 asks, is the debtor sole proprietor of any full or part-time business? And sole proprietor is the key phrase. A sole proprietorship is a business that the debtor operates as an individual and is not a separate legal entity such as a corporation, partnership, or LLC. So if the debtor owns a corporation, partnership, or LLC, or has an interest in those companies, those would show up in the schedules or statements elsewhere. This line 12 is only for sole proprietorship. So if the answer is no, then you check the box no. But in this particular case, George and Martha Washington do have a business. George owns a sole proprietorship, the Cherry Tree Service that we had seen earlier in question 4, or line 4. So I'd uncheck the no box, instead check the yes box, and identify the name of the business. Cherry Tree Services. And now this time they want the address of the Cherry Tree Services. So let me add the address. and that's in Alexandria, Virginia. Now, below the address of the business, there are 5 different checkboxes. And these are asking, is the debtor's business a particular type, a very particular type of business? And if the first 4 are not checked, then the bottom one, none of the above would apply. So let's go through each one of these. The first box is, they're asking, is George Washington's business a healthcare business, as that phrase is defined in the Bankruptcy Code? The second box is a single asset real estate. So they're asking, does George Washington own a sole proprietorship that is a single asset real estate business, as that term is defined in the Bankruptcy Code? The third box is stockbroker. You check that box if the debtor's business is being a stockbroker. The next box would be, is the debtor's business commodity broker, as defined again in the Bankruptcy Code? If the debtor's business aren't any of those special types of businesses, then you check the bottom box, none of the above. And in this particular case, George Washington's cherry tree services are none of those special categories of businesses. So he would check the bottom box, none of the above. Let's move on to question 13. Question 13 asks, is the debtor filing under Chapter 11 of the Bankruptcy Code? Now, if I was designing the forms, I would have put this question right next to the question earlier, which is question 7, that says, what chapter are you filing under? Because we've already said Chapter 7. So you couldn't say this is a Chapter 7 and a Chapter 13. So from my point of view, I would have put this question right next to question 7, asking about what chapter are you filing under. It's also somewhat repetitive, because when they ask in question number 7, what chapter are you filing under? One of the choices is Chapter 11. So if you don't check Chapter 11, but instead check Chapter 7 on line 7, then why do you even need this box for line 13? But nonetheless, it does ask, so you have to answer. And in this case, George and Martha Washington are filing a case under Chapter 7 and not under Chapter 11. So we would check the box, no, I'm not filing under Chapter 11. So let's move on to line 14, which is the start of part 4. Part 4 is titled, reported if the debtor has any hazardous property or any property that needs immediate attention. Line 14, the question is, do you own or have any property that poses or is alleged to pose a threat of imminent and identifiable hazard to public health or safety? Or do you own any property that needs immediate attention? So why do they have this question? This question is really designed to help the trustee identify very quickly, is there something that the trustee must do immediately? Because the Chapter 7 trustee becomes the trustee of the property that's the bankruptcy estate. So that might include any livestock, perishable goods, or any buildings that the debtor might own. And this question helps the trustee know, is there some sort of action he needs to take right away? So in this case, George and Martha Washington do not have any hazardous property. So they check the box, no. But if they did have it, they would uncheck no and instead check yes and say, what is the hazard? So let's use an example. The hazard is debtor owns a building in violation of the building code, which is in imminent danger of collapsing. That's indicating to the trustee that something has to be done right away to avoid the building collapsing. If instead this was not the case, then we simply delete all of this and check the box no, which is what we're going to do. And remember, the trustee does not know anything about the debtor's property at the time the case is filed. So when the case is filed, it's filed on paper and submitted to the clerk of the bankruptcy court. Well, it'll be a while before the trustee actually will have a chance to meet with a Section 341 meeting of creditors, usually between 20 and 40 days. And in the meantime, something bad could really be happening. So instead, the trustee would be alerted by this question 14 to take some sort of immediate action. Now let's scroll down to part 5. Part 5 is titled, Explain Your Efforts to Receive a Briefing About Credit Counseling. Credit counseling is required for all individuals before a bankruptcy case is filed, unless excused because of incapacity, disability, or active military duty. Line 15 requires the debtor to tell the court whether the debtor has received the briefing about credit counseling. And you can note below it even says law requires that you receive a briefing about credit counseling before you file for bankruptcy. You must truthfully check one of the following choices. Okay, so there's two separate columns, column for debtor 1 and column for debtor 2, just like there's been throughout this petition. So in column 1, you check the first box if the debtor has received the credit counseling briefing by an approved credit counseling agency within 100 days before filing of the bankruptcy petition, and the debtor has received a certificate of completion. The second box instead says, I've received a briefing from an approved credit counseling agency within 180 days before the bankruptcy petition was filed, but I did not have a certificate of completion. So that means that the debtor has completed the course, but has just not received it. And the third box says, I certify that I've asked for credit counseling services from an approved agency, but was unable to obtain those services during the 7 days after I made my request. This box is very rarely, if almost never, checked anymore. I believe it was started or was included originally when credit counseling was first beginning after the BAPSIPA law was passed, which I believe was 2005. Because at that point, the U.S. Trustee's Office had not really got up to speed and have enough credit counseling providers to make sure that everybody had the opportunity. But in the modern day, since it's online and almost everybody has access to the internet online, get credit counseling approval is pretty easy. But I imagine there might be some people who just don't have access to the internet and they don't have access to a telephone to do it over the phone, but that would be very few in the modern day. So in this particular case, the George and Martha Washington have received the credit counseling and they also have received the certificate of completion. So I'm going to check the box, yes, for the first one. And as for Martha, the same thing, check the box here. And in case you've never seen a certificate of credit counseling, here is an example of the certificate of credit counseling. Notice at the top it has a certificate number. That's a unique number, and I'm sure the U.S. Trustee's Office checks that number to make sure that there isn't any fraud going on. Below that, and by the way, this is just a single piece of paper. Below that is the certificate of counseling, the title, and it certifies that on a particular date and a particular time that somebody has received credit counseling from a certain company. In this case, it's CC Advising, Inc., which is an agency approved by the U.S. Trustee. You can see on the form it says an agency approved pursuant to 11 U.S.C. Section 111 to provide credit counseling in the Northern District of Illinois. So this is an example of an actual certificate of credit counseling used in a case filed in the Chicago Federal Court, which is the Northern District of Illinois. And that's it. It's just a single piece of paper. Let's scroll down to part 6, line 16. And part 6 starts with answering questions for reporting purposes. So line 16 asks the question, what kind of debts does the debtor have? And there's really two types of debts, primarily consumer debts and primarily business debts. Those are the two types for this question. And a business debt is a debt that has been incurred to obtain money for a business or investment or through the operation of a business or investment. Consumer debts are basically debts that are incurred by an individual primarily for a person, family, or household purpose. So, for example, a car could be either one of those types of debts. A car that is used for personal and family purposes would be a consumer debt, but a car that is purchased for a business would be a business debt. So you're looking for primarily a consumer debt or primarily a business debt. So the word primarily is very important. I believe primarily would be more than 50%. So let's give an example. Suppose you have a house with a mortgage of $300,000. And that would be a consumer debt because a house would be where the debtor family resides. And let's assume they have a business debts, which could be credit cards, car loans, think about any type of business-related debt. And let's assume those debts are $150,000. So the total amount of debt then would be $450,000 when you add the $300,000 mortgage to the $150,000 business debts. So then when they're asking what is primarily the amount of the debts, they have to ask basically what is 50% plus 1. So 50% of the 450,000 is 225,000. So which debt has more than 225,000? In this case, it would be the consumer debt because the mortgage was 300,000. So that means the debtor would then check 16A that says, yes, my debts are primarily consumer debts. Now, if he flipped that around and the debtor did same example, but the debtor didn't own the house and didn't have a mortgage on the house and say he rented, but still had $150,000 of business debt. In that case, the debts would be primarily business debts, in which if that was the case, then we would switch 16A and say no, and 16B, you would say yes. And then 16C says state the type of debts you owe that are not consumer debts or business debts. And this is really a way to flush out what debts do you think are the business debts. So let's use an example. If you had some sort of large machinery like grinding machines, if you are in the plastic recycling business, in which case 16C, you'd say something along the lines of secured debts relating to machinery. You don't have to be super specific here, but you have to add something in here to tell the trustee what are these debts. So you can be very general in the categories. I call it secured debts. It can also be unsecured debts. But a secured debt relating to machinery would be an example of a debtor purchasing some heavy-duty machinery that is very expensive. In the George and Martha Washington, they don't have any machinery, and all they have is consumer debts. So I'm going to take away 16C, 16B, I'm going to say no, and for 16A, I'm going to say yes, these are primarily consumer debts. Line 17 asks the question, are you filing under Chapter 7? I think this might be the third time they ask you, are you filing under Chapter 7? And the answer is yes, we are. This is consumer bankruptcy filing individually under Chapter 7. So then it asks the next question. Do you estimate that after any exempt property is excluded and administrative expenses are paid, that funds will be available for distribution to unsecured creditors? This, again, is really for reporting. And what it's basically saying is, after the trustee has been paid, is there any money available for the unsecured creditors? If the answer is no, then you check the no box. So, for example, imagine someone who rents an apartment, leases a car, and has lots of credit card debts, but no other real material assets. The rental is not owned. The home that's rented is not owned by the debtor. The car that is leased is not owned by the debtor. And he has miscellaneous clothes and some household goods. That would typically be a no asset case because there's really nothing of substantial value warranting a Chapter 7 trustee to open an estate, and therefore there'd be no money that'd be distributed to the unsecured creditors. And that's the case in George Washington and Martha Washington. So we're checking the box that yes, it's a Chapter 7, but no, we do not estimate there are any property that's going to go to a distribution to unsecured creditors. Let's scroll down to line 18. 18 asks, how many creditors does the debtor estimate that money is owed to? So just count up the number of creditors. So if there are 19 credit cards, that would be 19 creditors. And if there's a car loan, then make 20 creditors. If there's a mortgage, it'd be 21 creditors. And so simply just add up all the creditors by number, not by amount, just by the number. So in George and Martha Washington's case, there's approximately 30 creditors. So I would check the first box saying between 1 and 49 creditors. Line 19, how much do you estimate your assets to be worth? So this is simply an asset question. Add up the total of the value, the fair market value of all the assets of the debtor. So if he has a house, we'll say for $300,000 and a mortgage for $300,000, the value of the asset is still $300,000. It doesn't matter what the mortgage is, because that is a debt, not an asset. Add up the value of the cars if it's owned by the debtor. So a car that's leased is not owned by the debtor and would not be included. But a car that is owned by the debtor would be included even if there's a car loan. And then add up any household goods, any miscellaneous insurance policies, just any assets. And you'll see those assets on Schedule A/B. So one way to do that is to leave these blank until you finish all the other schedules, because then that'll give you exact numbers. So in this case, George and Martha Washington own a house and it's $300,000, and then the miscellaneous other assets they have maybe be another $50,000. So that would equal $400,000, and that's between this box, $100,001 and $500,000. The next line is line 20. How much do you estimate your liabilities to be? Okay, so this is almost the flip question of line 19. So we're only talking about liabilities. We don't care what's the value of the assets if it happens to be secured debts, just the liability. So count up the total amount of any mortgage, the total amount of any car loan, the total amount of any credit card debts, the total amount of any medical debts, and any taxes that might be owed, any other debts you might think of, including alimony and child support. Just total up all the liabilities. And liabilities are debts. Add them together and find out how much they are. So in this particular case of George and Martha, we're saying they have a mortgage of $300,000 and various other debts that'll be somewhere between, say, $50,000. So I would check the third box, indicating the total amount of all of George and Martha Washington's debts are between $100,000 and $500,000. Now the next part is part 7. That's where the signatures go. And let's read what the declaration is, because it's very important. Debtors need to know what they're signing. It says, I've examined this petition, and I declare under penalty of perjury that the information provided is true and correct. Remember, this is the debtor who's going to be signing, not the attorney. Continuing, if I have chosen to file under Chapter 7, I'm aware that I may proceed, if eligible, under Chapter 7, 11, 12, or 13 of Title 11, the United States Code. That's the Bankruptcy Code. Continuing, I understand the relief available under each chapter, and I choose to proceed under Chapter 7. So to sign this, they have to know what other relief may be available under the other chapters, and we'll talk about that later. Continuing on, if no attorney represents me and I did not pay or agree to pay someone who's not an attorney to help me fill out this document, I've obtained and read the notice required by 11 U.S.C. Section 342B. We'll talk about that notice later. I request relief in accordance with the chapter of Title 11, United States Code, specified in this petition. And in this particular one, we're saying Chapter 7. And then finally, and perhaps most important in terms of the signature, it says, I understand making a false statement, concealing property, or obtaining money or property by fraud in connection with a bankruptcy case can result in fines up to $250,000 or imprisonment for up to 20 years or both. And then it cites the Federal Criminal Code 18 U.S.C. So it's important the debtor knows that upon signing these documents, the debtor is stating under penalty of perjury that these things are accurate, and severe consequences could happen if in fact the debtor is lying about these things, or there's some sort of fraud. So each debtor would then sign by the X, but for illustration purposes, I will type the names George Washington and Martha Washington, and then add the date the debtor signed the petition. Okay. Moving on to the next part. This is where the debtor's attorney, would sign. So let's make sure the debtor's attorney understands what they're signing. It says, I, the attorney for the debtors, named in this petition, declare that I have informed the debtors about eligibility to proceed under Chapter 7, 11, 12, or 13 of Title 11 United States Code, and have explained the relief available under each chapter for which the person is eligible. I also certify that I have delivered to the debtors the notice required by 11 U.S.C. Section 342B. And in a case in which Section 707B4D applies, certify that I have no knowledge after an inquiry that the information in the schedules filed with the petition is incorrect. Now, we're going to talk about Section 342B a little later in this video, but Section 707B4D is not going to be discussed in this video, but is discussed in the course materials. So in this particular case, we're going to sign saying we're the attorney, and we're saying the attorney is Abe Lincoln, and he signed on the same date that Washington signed the petition. Then the attorney prints the name, then the firm name and address, and the attorney adds the contact phone number, email address, and bar number, and state of issuance. Now that we've completed Official Form 101, the voluntary petition for individuals filing for bankruptcy, it's time to move on to the companion form, the statement about the Social Security number of the debtor. It's Official Form 121. And what's the difference between the forms? The first form, the voluntary petition, identifies the debtor and the debtor's name, the debtor's address, what chapter the case is being filed, and other information. But as to the Social Security number, If you remember, the Social Security number was blacked out except for the last 4 digits. So line 3 of the voluntary petition only allowed the debtor to include the last 4 numbers of the Social Security. That's for privacy purposes. This form, Official Form 121, is a statement about the Social Security number and will identify the complete Social Security number. And they do that for privacy reasons. The official petition is open to the public. Anybody can see that. You can get online and see it. You can go to the actual clerk of the court and see it. And that information will be known to anybody who wants to. But from a privacy point of view, it's also open to felons and vandals and people who want to cause mischief. So what they did a couple years ago is they came up with a separate form, this Official Form 121. This statement about the Social Security number will identify the complete Social Security number, but it'll remain private. So when this form is filed, only the court and the trustees will be able to see the full Social Security number. That number will not be given out to the public at large. So let's go through the form. The instructions say, quote, use this form to tell the court about any Social Security or federal individual taxpayer identification numbers. By the way, that's the ITIN we talked about, that the debtor has used. Do not file this form as part of the public case file. This form must be submitted separately and must not be included in the court's public electronic records. Please consult local court procedures for submission requirements. After the debtor files the statement about Social Security numbers, the clerk of the court will automatically restrict public access to the statement. But as to the people who are supposed to receive this, like the court and the trustee, they'll receive the entire form and see the entire Social Security number. So let's go down and look at the form. Part 1, the title is Tell the Court About Yourself and Your Spouse if your spouse is filing with you. So this form looks a lot like the petition in the sense that it has 2 columns, one for debtor 1 and one for debtor 2. If the case is an individual case, then only debtor 1 would have information. But in this case of George and Martha Washington, both are filing together a joint petition. So on line 1, we'll include both names. So let's do that. First name is George, no middle name, and last name Washington. For debtor 2, that would be Martha Washington, the exact same names as appearing on the petition. Now let's scroll down to part 2. It's titled, Tell the Court About All of Your Social Security numbers and federal individual taxpayer identification numbers. So if you have more than one, you have to list all of them. Now it would be rare to have more than one, and I've actually never seen it in all my years of practice, but it might be possible if something went wrong from a fraudulent point of view and they gave you a new Social Security number. I don't know if that happens. I've never seen that, but it's also there for those people who have illegally used more than one Social Security number. So imagine you are an illegal person who comes in and wrongly uses somebody else's Social Security number or numbers, or you use one wrongly and then you get your own Social Security number legitimately. From a bankruptcy point of view, you have to include all of the Social Security numbers that you have used. So let's add the Social Security numbers for George Washington and Martha Washington. On line 3, it says all federal individual taxpayer identification numbers that the debtor has used. George Washington has not used one, so I'm going to click the box. You do not have an ITIN. Martha also does not have an ITIN number, so we're going to check the box. Not used one. At the very bottom of the statement, they sign their names under penalty of perjury, George and Martha Washington. Then they date the statement. And that completes Official Form 121, the statement about Social Security numbers. Now that we've completed the statement about the debtor's Social Security number, it's time to move on to the next document that must be filed at the time the petition is filed. And that is the verification of the creditor's matrix as well as the creditor's matrix. So what is a creditor's matrix? A creditor's matrix is really an old-fashioned term. It's just a listing of all of the creditors of the debtor. Okay? And I believe they call it a matrix because in the old days, it had to be inserted in columns and a special way of columns. And I think it's because of the old mailing labels. For those attorneys and people who are old enough to remember mailing labels would go through the printer and then they would peel off the labels and put them onto an envelope. I know some people may still use those, but it's not as common as it used to be. So the formatting of the creditor list was called a matrix because I believe it was easier for the clerk of the court to use those mailing labels. So it's kind of an arcane thing, but it still exists. So first of all, let's look at the verification of the creditor's matrix. At the very top, it'll identify the court. And then below that, it says in re, and that'd be the name of the debtors, and make sure both debtors are listed if this is a joint case. To the right, it says case number, and the first time this document is filed, which would be with the petition, there would not be a case number because the case number is unknown at the time the case is being filed. But if for some reason this is filed later or amended, you certainly would put a case number down. And the below the case number is the chapter number. And in this case, it's Chapter 7 because George and Martha Washington are filing a Chapter 7. So the document is called Verification of Creditors Matrix. And below that, to the right, it says the number of creditors. And in this case, we're saying there's 15 creditors in which Martha and George Washington owe money. Okay, moving down the form. It says the above named debtors hereby verifies that the list of creditors is true and correct to the best of my or our knowledge. And it's dated and then signed by both debtors. So again, it's important. The debtors are signing this. It must be accurate. So below is an example of a creditor's matrix. And you can see that it has columns. And that's just the old-fashioned way of doing it, I believe back to the mailing label idea. But that's the way they want to have it. And maybe in some jurisdictions they still do it by mailing label, although I doubt it. Everything seems to be computerized now. But nonetheless, that's the old-fashioned way of doing it. And that's the way that a lot of the clerks of the courts demand it. So they just list it. It can be listed in alphabetical order. That's the way software does that. And it's the best way to do it as well as in alphabetical order. You can see it just goes down to the bottom. And then once all the creditors are listed, the form is done. So the actual creditors matrix, which is a required document by the code, lists all of the creditors, and then the verification indicates to the court that the debtor is saying these are all of the creditors. So let's move on to the next document. Now let's discuss Section 342B notice. Officially, it's called the, quote, notice required by 11 U.S.C. Section 342B for individuals filing for bankruptcy, unquote. Very commonly known as simply the Section 342B notice. The first box on the left says this notice is for you if you are an individual filing for bankruptcy and your debts are primarily consumer debts, reminding the debtor that consumer debts are defined in the code as incurred by an individual primarily for a personal, family, or household purpose. You may remember on the petition on line 16, it asks you to identify are the debts primarily consumer debts or primarily business debts. Okay? And that's the reason for this form. If your debts are primarily business debts, this form is not required. And what does this form really do? It really gives background information to the debtor to make sure that the debtor is fully knowledgeable about each of the individual chapters and which chapter is the appropriate chapter for the debtor to file, as well as the importance that the debtor be truthful on the documents, leading to any criminal proceedings, charges, or allegations in the event that it found out that these documents are not accurate. So the debtor needs to take it very seriously. So this form has 4 pages, and each page is divided into 2 columns. But it's a critical form, so we're going to go through it very carefully. On the left side of the form, it says the types of bankruptcy that are available to individuals, and there's 4 of them. Chapter 7, liquidation. Chapter 11, reorganization. Chapter 12, voluntary repayment plan for farmers and family fishermen. And Chapter 13, voluntary repayment plan for individuals with regular income. On the right side, it starts to identify information about each one of the chapters, beginning with Chapter 7, the liquidation. The first thing it says is the different fees that are charged. So as of this recording, which is 2020, the filing fee for Chapter 7 is $335. Chapter 7 is for individuals who have financial difficulty preventing them from paying their debts and who are willing to allow their non-exempt property to be used to pay their creditors. The primary purpose of filing under Chapter 7 is to have your debts discharged. The bankruptcy discharge relieves you after bankruptcy from having to pay many of your pre-bankruptcy debts. Exceptions exist for particular debts, and liens on property may still be enforced after discharge. For example, a creditor may have the right to foreclose a home mortgage or repossess an automobile. However, if the court finds that you have committed certain kinds of improper conduct described in the Bankruptcy Code, the court may deny the discharge. You should know that even if you file Chapter 7 and you receive a discharge, some debts are not discharged under the law. Therefore, you may still be responsible to pay. Some of those debts include most taxes, most student loans, and domestic support and property settlement obligations. Most fines, penalties, foreclosures, forfeitures, and criminal restitution obligations, and certain debts that are not listed on the bankruptcy papers. You may also be required to pay debts arising from fraud or theft, fraud or defalcation while acting in breach of fiduciary capacity, intentional injuries that you inflicted, and death or personal injury caused by operating a motor vehicle, vessel, aircraft, while intoxicated from alcohol or drugs. If your debts are primarily consumer debts, the court can dismiss your Chapter 7 case if it finds that you have enough money to repay creditors a certain amount. You must file Chapter 7 Statement of your current monthly income, Official Form 122A-1, which is addressed in a separate course. If you are an individual filing for bankruptcy under Chapter 7, this form will determine your current monthly income and compare whether your current income is more than the median income that applies in your state. If your income is not above the median for your state, you will not have to complete the other Chapter 7 form, the companion Chapter 7 Means Test Calculation, Official Form 122A-2. If your income is above the median for your state, you must file a second form, the Chapter 7 Means Test Calculation, Official Form 122A-2. The calculation on the form, sometimes called the means test, deduct from your income living expenses and payments on certain debts to determine any amount available to pay unsecured creditors. If your income is more than the median income for your state of residence and family size, depending on the results of the means test, the U.S. trustee, bankruptcy administrator, or creditors can file a motion to dismiss your case under Section 07B of the Bankruptcy Code. If a motion is filed, the court will decide if your case should be dismissed. To avoid dismissal, you may choose to proceed under another chapter of the Bankruptcy Code. If you're an individual filing for Chapter 7 bankruptcy, the trustee may sell your property to pay your debts, subject to your right to exempt the property or a portion of the proceeds from the sale of the property. The property and the proceeds from the property that your bankruptcy trust sells or liquidates that you are entitled to is called an exempt property. Exemptions may enable you to keep your home, a car, clothing, and household items, or to receive some of the proceeds if the property is sold. But exemptions are not automatic. To exempt property, you must list on Schedule C the property you claim as exempt, Official Form 106C. If you do not list the property, the trustee may sell it and pay all of the proceeds to your creditors. Now, the Section 342B notice also talks about Chapter 11 and describes that for the debtor. And it starts with the total fee, which is $1,717. Chapter 11 is often used for reorganizing a business, but is also available to individuals. The provisions of Chapter 11 are too complicated to summarize briefly. Before going on to Chapter 12, we have to read the black box at the top of the page. Very important. And I literally read this to my clients to make sure they understand the importance of honesty and the ramifications for bankruptcy fraud. The warning reads as follows. Because bankruptcy can have serious long-term financial and legal consequences, including loss of your property, you should hire an attorney and carefully consider all your options before you file. Only an attorney can give you legal advice about what can happen as a result of the filing for bankruptcy and what your options are. If you do file for bankruptcy, an attorney can help you fill out the forms properly and protect you, your family, your home, and your possessions. Although the law allows you to represent yourself in bankruptcy court, you should understand that many people find it difficult to represent themselves successfully. The rules are technical, and a mistake or inaction may harm you. If you file without an attorney, you are still responsible for knowing and following all of the legal requirements. You should not file for bankruptcy if you are not eligible to file, or if you do not intend to file the necessary documents. Bankruptcy fraud is a serious crime. You could be fined and imprisoned if you commit fraud in your bankruptcy case. Making a false statement, concealing property, or obtaining money or property by fraud in connection with a bankruptcy case can result in fines up to $250,000 or imprisonment for up to 20 years or both, citing 18 U.S.C., which is the criminal code. So this is a very serious warning, and it's very important the debtor understand not to take this lightly, and that bankruptcy fraud is actually a criminal violation. So moving on with the form, it now describes what Chapter 12 is to the debtor, which is a repayment plan for family farmers or fishermen. The form then says what is the total filing fee, which is $275 as of the tape recording. And similar to Chapter 13, Chapter 12 permits family farmers and fishermen to repay their debts over a period of time using future earnings and to discharge some debts that are not paid. Now, Chapter 13 is also described, and the title is Repayment Plan for Individuals with Regular Income, and the filing fee is $310 at the time of this tape recording. Chapter 13 is for individuals who have regular income and would like to pay all or part of their debts in installments over a period of time, and to discharge some debts that are not paid. You are eligible for Chapter 13 only if your debts are not more than certain dollar amounts set forth in Section 109 of the Bankruptcy Code. Under Chapter 13, you must file with the court a plan to repay your creditors all or part of the money that you owe them, usually using your future earnings. If the court approves your plan, the court will allow you to repay your debts as adjusted by the plan within 3 years or 5 years, depending on your income and other factors. After you make all the payments under your plan, many of your debts are discharged. The debts that are not discharged and that you may still be responsible to pay include domestic support obligations, which is really child support and alimony, most student loans, certain taxes, debts for fraud or theft, debts for fraud or defalcation while acting in a fiduciary capacity, most criminal fines and restitution obligations, certain debts that are not listed in your bankruptcy papers, certain debts for any acts that cause death or personal injury, and certain long-term secured debts. Now, the last page of the Section 342B notice starts with a warning box. It says, warning, file your forms on time. Section 521A1 of the Bankruptcy Code requires that you promptly file detailed information about your creditors, assets, liability, income, expenses, and general financial conditions. For the attorneys, those are the schedules A/B through J, as well as the various statements. They must be filed on time or the case could be dismissed. The form continues with bankruptcy crimes have serious consequences. If you knowingly and fraudulently conceal assets or make a false oath or statement under penalty of perjury, either orally or in writing, in connection with a bankruptcy case, you may be fined, imprisoned, or both. All information you supply in connection with a bankruptcy case is subject to examination by the Attorney General, acting through the Office of the U.S. Trustee, the Office of the U.S. Attorney, and other offices and employees of the U.S. Department of Justice. The next portion of the form says make sure that the court has your mailing address. The bankruptcy court sends notices to the mailing addresses you list on the voluntary petition for individuals filing for bankruptcy. To ensure that you receive information about your case, Bankruptcy Rule 4002 requires that you notify the court of any change in your address. A married couple may file a bankruptcy case together called a joint case. If you file a joint case and each spouse lists the same mailing address on the bankruptcy petition, the bankruptcy court generally will mail you and your spouse one copy of each notice unless you file a statement with the court asking that each spouse receive separate copies. And the last section of the Section 342B notice says, understand which services you could receive from credit counseling agencies. The law generally requires that you receive a credit counseling briefing from an approved credit counseling agency. If you are filing a joint case, both spouses must receive the briefing. With limited exceptions, you must receive it within 180 days before you file your bankruptcy petition. This briefing is usually conducted by telephone or the internet. In addition, after filing a bankruptcy case, you generally must complete a financial management instructional course before you can receive a discharge. If you are filing a joint case, both spouses must complete the course. And you can obtain a list of agencies approved to provide both the briefing and the instructional courses at the court's website. As for residents of Alabama and North Carolina, there's a different website. If you do not have access to a computer, the clerk of the bankruptcy court may be able to help you obtain the list. So that completes the end of the Section 342B notice. I urge the attorneys to have the debtor sign the Section 342B notice to make sure that you can prove that you have provided the notice to the debtor. And with that, that concludes this video on the filing of the petition and the required documents that need to be filed along with the petition. There are other documents that could be filed with the petition, like the schedules and statements, but those are not required to be filed with the petition. And those documents are all discussed in separate videos. Thank you for listening to this video, and please spread the word to your friends and family that the Do-It-Yourself Bankruptcy Training Academy is available to help file the Chapter 7 bankruptcy petition, Schedules A through J, the Statement of Intent, the Chapter 7 statement of your current monthly income, and the Chapter 7 means test calculation. You can contact the Do-It-Yourself Bankruptcy Training Academy via their contact page at www.diy-bankruptcy.info. Note that this is not a .com website, but .info. Enjoy all of the Academy's other online videos and keep on learning. Before we begin examining the bankruptcy document, consider reading the suggested book, Do-It-Yourself Guide to Filing Chapter 7 Bankruptcy. This desk reference book provides step-by-step instructions for filing a Chapter 7 petition, Schedules A through J, the Statement of Financial Affairs, the Statement of Intent, the Chapter 7 Statement of your current monthly income, and the Chapter 7 Means Test Calculation. The book is available at www.diy-bankruptcy.info/shop or go to www.diy-bankruptcy.info and click the bookstore link on the main menu.